All right. It's 1 o'clock. Are both parties ready to begin?
Yep. Yes.
Court reporter, you ready? Dan? I'd like to call the meeting together for the McHenry County Electoral Board objection hearing. The board is reconvened to hear the petitions of the objectors as listed in the McHenry County Electoral Board docket. Originally for 6/13/2024. The objections were filed on 6/7/2024. Notice of call was given to McHenry County Electoral Board on 6/10/2024. The board's notices of today's hearings were served on the parties as required by the election code. The rules that were adopted in the first meeting will continue to be in effect during this meeting. Note that because of the possibility of judicial review of the board's decisions, a court reporter is present to ensure that a verbatim transcript of today's proceedings is made. Electoral board hearings are subject to the Open Meetings Act, and public notice was posted in writing before this hearing. I understand there's no one interested in public comment at this time.
Mr. Terrio,
yes.
To correct the record, I know that that's a presumption based upon what had been articulated earlier. I believe that it's important that you actually ask the public for comment before you move on.
So I was saying it appears that there is nobody, no one had signed up, there's no interest, and if there's none further from the room, then I'd be glad to carry on. This docket contains 2 objections. First hearing is for 24MCEB02, the objection of Dina Nicole Krieger to the nomination of Stephen A. Firak as a candidate for McHenry County Board Member District 5. The second hearing is 24MCEB03, the objection of Carl Kaminsky to the nomination of Arnie Waltmeyer as a candidate for McHenry County Board Member District 6. Objector, are you ready to proceed?
Yes.
Please, you don't need to identify yourself for the court. And in terms of oaths, you wouldn't need to do an oath if Ms. Krieger is going to testify. I think she'll need to do an oath if that comes to pass.
Yes. Well, we intend to stand on our written objection and for the reasons that are set forth in that written objection. And you'll note that her written objection is a verified written objection. So it's already sworn testimony. I can't actually go outside of the scope of that written objection. There's various case law with respect to that. Now, unless my opposing counsel raises something that is a purported affirmative defense or something along those lines, then I can address that. But the issue is clear. They had the wrong group of individuals, being the Democratic Central Committee, served to caucus in their candidate, when in fact they were required to have the precinct committeemen of that district caucus in. And as I'm sure, Mr. Terrio, you'll recall, there was a matter that went to the Illinois Supreme Court entitled Terrio versus McHenry Township, I believe. And in that, the court looked at the statutory obligations to look at the instruments that are before them and not to go beyond them for the purposes of the functions of any action taken. And because this committee has to look and examine the nominating papers. They can't look to beyond the nominating papers. And so if you look at the nominating papers themselves, it's clear that the candidates in both of these cases did not comply with the statute as set forth within the objection petition.
at the end of your presentation, Mr. Hanlon?
For this objection petition, yes.
Okay, very good. Ms. Ridings.
Thank you. I did file a brief in opposition to the objection, and I understand that that was circulated to all the members of the board, and we've had an opportunity to review that. So I won't belabor it too much, but our argument in defense is simple and straightforward. There are some issues as a matter of law that, as we argue, conclude that the objection itself does not even state a prima facie case of any violation of any Illinois law. And that is because the objection seems to focus on the candidates' petitions. They were referred to as nomination petition papers. There was a claim that the petitions were invalid, that the nominating petitions and paperwork was defective somehow, and that, again, the nomination petitions are insufficient. We set forth in our brief the argument that the petitions are defined by Illinois law, and the petitions themselves don't recite who voted or when or for what, and there is no defect alleged as to the actual petitions. The nominating papers themselves do contain the petitions, but the other documents that were included were a resolution to fill a vacancy in nomination, statement of candidacy, loyalty oath, and statement of economic interest. The resolution itself, if the board were to construe the objection generously to include that instead of a petition, the law sets forth what a resolution should contain. And that's in section 5/7-11.1, subparagraph 4. And I set that forth on page 3 of the brief, where what needs to be in that resolution is the name of the original nominee, the date on which the vacancy occurred, and the name and address of the nominee selected to fill the vacancy, and the date of selection. There's further language in that statutory section as to what other documents should be included, but notably, the statute is silent as to any other requirements as to what should or should not be included in that resolution to fill a vacancy. And it is clear under the applicable legal authority here that this board does not have the ability to read into Illinois statute requirements that are not set forth, especially when the goal is to use such additional requirements to render candidates' papers defective, sufficiently defective that he or she would not be certified to be on the ballot. The third reason why the candidate contends that the objection fails to even state as a matter of law any defect is that when we look at the applicable law as to who may nominate a candidate, it is set forth as the central committee or the appropriate county board district committee. And the voting strength of the voters in those nominations is also cited, and that's on page 4 of our brief, and that was contained in the objector's original objection. The actual document that was filed by the candidate, and it is attached as Exhibit A to our brief, provides blanks to fill in. And the candidate used the form approved by the Illinois State Board of Elections. And in that form, there is a place for a McHenry County Central Committee, and then there's blank Democratic Party, and then it's added to that in and for the County Board District 5. And that is how this candidate filled out that form. And I myself am unfamiliar with the traditional way of filling out these forms, but intuitively, when you look at the form itself, the resolution has a place for a general designation and then a place for a specific designation. The candidate here, the resolution says it's the Central Committee of the County Party, and in and for County Board District 5. It's a specific, and underneath the space where that is filled in, there's a parenthetical indication to the person filling out the document. County Board District. That's where I think a person would put that. And that's what it says on the face of the resolution. And so because the resolution plainly states that the resolution is specific to the County Board District 5, I think that as a matter of law renders the objection void. It does not speak to any defect when it's set forth as it is in the form prescribed to be used by the State Board of Elections. Going on, the definition on page 5 of the candidate's brief, under 10 ILCS section 5/7-8 subparagraph D, it defines what is a county central committee. And in that definition, it's defined that the central committee already is composed of members of subunits of the central party, the county party. That's the statutory definition. So even assuming that the candidate had somehow filled out the resolution, or the party had filled out the resolution improperly, they could have failed to even designate for County Board District 6. And that still would not be a defect because under the statutory definitions, the county central party includes the specific district parties. The latter portion of the brief is as to a matter of fact that in case there's any concern that the Democratic Party failed to include the necessary people to vote in and fill a vacancy, that in fact the party conducted that vote according to its own internal rules. They had the specific committee persons of the sub-district, District 5, do the voting. They memorialize that. And under the applicable law, notably Carla Sayre versus the Will County Officers Electoral Board, that's 20977 Northeast 2nd 298. And it was a 3rd district case, 2012. The electoral boards are not in the business of dictating to political parties how they can conduct their business. The concerns of this board are whether the candidates have conducted their candidacy for certification in a way that is not substantially defective, not fraudulent, that preserves the integrity of the electoral process. None of the concerns raised by the objector speak to how that perceived defect could impact the integrity of the electoral process here in McHenry County. And for all of those reasons, we think that the objections should be denied. They are certainly permitted, and this is what democracy looks like, that you can challenge a candidate's documents. We think that the electoral board, once it looks at the documents here that have been submitted, are perfectly appropriate, and there's no defect sufficient to make this candidate not capable of being certified.
May I reply?
You may.
I just want to confirm with opposing counsel she's concluded.
I am, thank you.
Very well. First of all, opposing counsel's argument serves to undermine the plain, clear language contained within the Electoral Code and serves to undermine the statutory framework that's set forth by the legislature. When you look at the idea that the nominating papers referenced in the objection petition, as opposed to just simply the nominating petitions signatures. The issue here is that on its face, within the 4 corners of the nominating papers, is a representation by the two respective candidates, and I'm just going to adopt these arguments for the secondary one unless there's an objection to that. But with respect to the nominating papers, there is a statement there that the Central Committee did it. And while my learned colleague points out that you can have within the statutory definition of what the Central Committee consists of, in this particular case, they did not indicate that it was exclusively the districts that these two candidates are running in. And so a board, and in this case, if you look at the Central Committee of the Democratic Party, it may have those component parts, but what's clear from the express language used in the nominating papers, that's the collective set of documents, that within those papers, the representation is that the Central Committee voted, not the committee of that the respective districts. And so it serves as a perversion of the English language to take that definition and say that because it has a part of it that would be included in the whole, that somehow only, or that when the whole voted, somehow it imputes only to that part. And so, we're sitting here in a room. I have my learned colleague on one side, myself on the other side. And if I were to draw a line down the center of this room and say that all those persons on that side are part of a group, and obviously because they're part of that group, they must have adopted my learned colleague's position, and vice versa. We wouldn't accept that because it's contrary to basic fundamental logic. So the miscues with respect to the application of the definitions that are in there. My opposing counsel also referenced the form that was delegated, the form that was used to make the respective submissions. Nowhere in any state statute or in any case does it say that a form supersedes compliance with the statute. If you don't comply with the statute, you didn't comply with the statute. And it's as simple as that. And so there is no representation made by the respective candidates that the proper committee of the Democratic Party, being a committee of the committeemen of the respective district that the two candidates are running for, would have or had voted with respect to that position. That position being the nomination of this particular candidate. And therefore, the argument that's been advanced with respect to the form that was used and its statutory implications by way of the definitions, those are all inapposite arguments that are designed to basically mislead you. The basic premise of the objection, and I appreciate my learned colleagues' extensive work on that, but it basically says in general terms that we should have fair, honest, open elections. This is democracy. Well, elections are predicated upon the election code, and the legislature set forth the requirements to be placed on the ballot. And that is part of the fair and equitable democratic process. And if you don't comply with it, the remedy here is to strike the candidacy, because this is a material difference. It's not just some venial problem. In the sense that we're talking about the caucusing by the Central Committee versus caucusing by the precinct committeemen in a particular district. And since there isn't anything that shows that the precinct committeemen in the particular districts approved and voted on this particular candidacy, it's improper to caucus them in because they had missed the primary. Now, my learned colleague also referenced a case out of Will County. That case does not stand for the proposition that this board should ignore all statutory framework to be considered as it applies to this particular issue. There isn't a case on point to this particular issue. I'll concede that. If there had been a case, I probably would have cited it in the opening objection. However, at this point in time, the general framework, the general statutory framework that's referenced in my opposing counsel's brief, basically says the general principles of an election. We're not arguing about the general principle of election. We're arguing about whether or not these two candidates complied with the statutory framework that is mandated by statute, and whether or not they substantially complied with that statute. And our position is they did not substantially comply with that statute because they did not have a committee of the precinct committeemen undertake to caucus in these two respective candidates. And 1 second. Is there anything she would add?
That sounds great.
She says it sounds great.
Where in the statute does that require that?
When you say we're in the
Where
statute.
in the statute does
The
that?
statute says the appropriate committee, and if you look at the objection petition, I cited and quoted the language from that act. It says that the appropriate committee is the committeeman.
But aren't you missing the disjunctive or in that sentence? I mean, the entire sentence, is this the sentence you're referring to? Except as, this is section 11.13 of the election code, except as otherwise provided in paragraph 3.5, which doesn't apply here, right?
That's correct.
If the vacancy in office occurs after the last date provided in section 712 for filing nomination papers for any elected county office or vacancy in nomination shall be deemed to have occurred, and the county central committee or the appropriate county board district committee of each established political party shall nominate by resolution a candidate to fill such vacancy in the nomination for election to such office as such general election. So where...
It's in the subsequent section that I cited. It says that the appropriate committee shall be the committee of the committeemen.
But then wouldn't that only apply if it were not the appropriate, if there were not the county central committee?
No, I don't believe so.
What's your authority for that?
It's just simply the language in the statute. If you disagree with me as to its construction, Justice Scalia wrote a book entitled A Matter of Interpretation. If you also look, the Illinois Supreme Court, there was a case involving a FOIA request. And that case was Edgar County Watchdogs versus Joliet Township. And in that case, and also, 1 second, it'll come to me. I'll come back to you with the other citation. But the citation in the Joliet Township case, when you were looking at the disjunctive nature of whether or not the language in interpreting the FOIA statute was willful and wanton or bad faith. And the 2nd District Appellate Court, the court that, I'm sorry, not the 3rd District, said that was to be read conjunctively, meaning all 3 of those things, not just 2 of those things. Then there was also the Rock River Times case in which the same concept where the or was inferred by the appellate court and by the Supreme Court to mean all 3 things as opposed to just 1 thing. And I can tell you that I'm beguiled from time to time by that context. But when I look at multiple occasions where the appellate court uses the word or to mean really and, that's the implication. So with respect to the disjunctive nature of it, it's really conjunctive.
Councilman, do you have any response to that?
To Council's argument?
That argument?
I do. Not just on that specific point, though. I understand Council's argument is that the candidate's argument, as set forth in the brief, is that completion of a form should somehow take the place of compliance with the statute. I don't believe that there is any clear statutory language that the candidate has violated. I don't find any legal authority that says a candidate must affirmatively state that exclusively the sub-district, the precinct committeemen were the only voters. That is precisely reading into the statute that says what the resolution should contain. And the argument from counsel is, well, they didn't say these other things. They didn't say with specificity. Well, respectfully, there's no requirement under the law that they do so. They do have to comply with the law as to what information they put on the resolution. And I cited to the law that says what the resolution should contain. There's no claim that none of those things were in there. I think the question is whether a candidate should affirmatively state things that could possibly be questioned. The answer to that is a resounding no. And since there's no legal authority that says they need to do that, this is not the candidate saying, we complied with the form, but we didn't comply with the statute. This is the candidate saying, there's absolutely nothing wrong with the nominating papers here whatsoever. And for that reason, the objection should be denied.
If I am looking for a pinpoint site for you for the conjunctive and disjunctive issue. Williams versus Bruscato, that's 2021, Ill App Second, 190971. And that's where the appellate court articulated that the phrase willfully intentionally failed to comply with this act, comma, or otherwise acted in bad faith must be read collectively and not disjunctively as you suggested, counsel. In the Williams versus Bruscato case, I believe they cited to the Rock River Times case, which would have been a second district case, which is 2012, Ill App Second, 110879. If you need me to repeat that site in case you want to look them up, I'm happy to do that. And I just wanted to let you all know that someone watched this at the last hearing and pointed out that I had a bald spot on the back of my head, so I promised I would give him a tap. They're probably laughing right now.
Well, it seems like the language there from that case that you cited, Williams versus Bruscato, the phrase willfully and intentionally in section 11J are read together with otherwise in bad faith.
Or otherwise. So just like you had the or in the statute that you looked at, this court didn't read that as disjunctively to the, and if you look at the two commas in the phrase, willfully intentionally failed to comply with the act, comma, or otherwise acted in bad faith. The operative view that the appellate court inferred from that was the collective, set of those things. So if you use the same logic with respect to the phrase that you asked me if it should be looked at disjunctively, I contend that that same language, that same comma phrasing, or the phraseology of how that or sits in there, makes it to be interpreted in the same fashion that the Bruscato case would have been interpreted.
What are your feelings about that?
Well, are we going to discuss it? Or are they included in last
Track of
presentation?
whose Ms. Writing spoke, and then Mr. Hanlon chimed in with the specific site. Did you have anything that you want to reply back to Ms. Writing's commentary?
Well, I had already done that.
Just wanted to see if there's anything else you wanted to bring.
No, thank you, sir.
Okay.
Anything further from you?
No, thank you. We stand on our feet.
All right. So at this point, we deliberate, and we do so in public. So you get to hear what's going on in our heads as we do it.
All right, well, if I'll start off a little bit if you don't mind.
Sure.
Normally, the court looks to the plain language of the statute as the best indicator of the legislature's intent, and that's Allstate Insurance Company versus Menards, Inc., 202 Illinois 2nd, 586. And when the statute's language is clear, it will be given effect without resort to other aids of statutory construction, which is Peterson versus Wallach, W-A-L-L-A-C-H, 198 Illinois 2nd, 439. And in this case, to me, it is clear, the plain language of the statute is either the central committee or the committeeman could do the nominating. And in this case, since it was the central committee, I think it's within the letter of the law, and therefore, in my opinion, the objection should be denied.
That's my opinion as well. I think it's clear it's either the central committee or the appropriate county or district committee. And I also think the objection should be denied.
So so I'm conflicted. So just below where you had read from Mr. Hanlon's objection, a few lines farther down, it says, in the nomination proceedings to fill such vacancy and nomination, each member of the county central committee or the county board district committee, as the case may be, shall have the voting strength, so on and so forth, set for. And in farther down, part numbered 7, and again in his pleadings, he talks about the election code establishes that the appropriate committee be committee persons of the precincts in District 5. And so this is and so I agree with you about the plain reading of the law, but I don't know that I don't necessarily agree that it's plain.
And if you'd like me to respond to that, Joe, if we're discussing.
Yeah, we are, yeah.
As the case may be, I believe modifies if the central committee does it or if the committee does it. So that's as the case may be, as far as I construe the statute.
So, why would there be a county board committee?
Well, the statute allows it either, it can do either one of those can do it. So it doesn't, in my mind, demand that it be done, but in the event that either one of those two, for lack of a better expression, bodies could fulfill that role. And then also in light of the fact that ballot access is extremely important.
Yeah.
And if there is a close call like that, I think the legislative intent is to encourage access to the ballot.
And so you don't read, again, going back to the objector's objection, number 6, that the reason they make that distinction is because there's a context for a county level versus a county board level meeting that could occur.
I'm not sure if that's exactly follows, but.
Well, they talk about you could have a county or a county board district, as the case may be. Are they covering both circumstances by saying these are the procedures regardless of which of those committees may have been convened? Because the other, and this is, I guess, more, I hate to say getting in the weeds on this, but it could then be possible that it could be possible that a central committee could nominate a county board member without having representation from that district. Any thoughts or feelings about it? I don't need to be leaving you out of the discussion, but
that's okay. I've read these sections countless times in the last couple of weeks, and to me, there's nothing that says that it shall be the county board district committee. It's an either or. If they intended it for that it had to be the county board district committee to do the nomination, then I would think there would be a shall. I would say something to the effect of the county board district committee shall have the voting strength, or it's not an either or. It would be more definitive.
And to the case that counsel cited, Williams versus Briscato, that otherwise acted in bad faith kind of defines the term of willful and wanton. I believe that was the expression that preceded it, the antecedent. And in this case, the clause that follows the disjunctive or doesn't modify the clause that precedes it. So the central Central Committee, the County Central Committee or the appropriate county board district committee of each established political party. So the appropriate county board district committee doesn't describe the County Central Committee in the same parallel structure as the otherwise acting in bad faith modifies the I can get the exact language on it. So in this case, I believe they both stand distinctly alone as either Joe or Tom could turn off the lights. Doesn't mean Joe and Tom have to turn off the lights. Joe can turn off the lights or Tom can turn off the lights. And that's how I read the statute, is to give the plain ordinary meaning of the language.
Well,
Mr. Terrio,
yes.
at this point in time, that was a yes, right? We wish to withdraw our objection petition. Therefore, the board doesn't need to make a decision.
Any objection to that?
I think that once the board starts to deliberate and the objector has noticed that 2 out of 3 of the board members are, I don't know that that's permissible. If it is, you know, I have no objection, I know.
Well, that would permanently end this proceeding or any challenges. Is that right, Mr. Hanlon?
That it would be correct.
I think
Is that as to both objections?
As to both objections, Mr. Hanlon?
Yes.
I find that satisfactory.
Yeah, I'm agreeable with you.
I agree.
Thank you.
So based on council's representation for the 2 objectors, that they will be withdrawing their objection, and that would conclude the entire challenge to the candidates.
I would suggest that you still go on record with that second objection, call that case
Yes.
and go on record with that, so there is a record of it. Very good.
Yes. All right. And should we conclude this one first, perhaps, and then call the next one afterwards?
Yes.
And proceed in the same manner?
All right. So
Make you read that again.
So in the matter of 24 MCEB 02, the objection of Dean and Nicole Krieger, the objection has been withdrawn. And that concludes that discussion. Without objection, then the second hearing is 24 MCEB 03, the objection of Carl Kaminsky to the nomination of Arnie Waltmeyer as a candidate for District 6.
And if the parties could identify themselves for the record, please.
Sure, Robert Hanlon on behalf of the objector, and the objector is present and sitting to my right near the wall.
Jeannie Writings on behalf of the candidate, and the candidate is present in the gallery.
And Mr. Hanlon, do you have any preliminary,
Yes, we wish to withdraw the objection petition.
thank you, Mr. Hanlon.
Thank you.
Very good. All right. So then in the case of 24 MCEB 03, objection of Carl Kaminsky has been withdrawn. That concludes our business here today. Thank you very much.